Good morning, members. This is the appointed time and we have a quorum. So I call to order the meeting of the panel on security. Because of the epidemic, this meeting is to be conducted remotely. And let me remind members that you should use the virtual background function of Zoom during the meeting to show the appropriate color. And you should also keep the video camera on in order to show your faces. Item 1 on the agenda. Information papers issued since the last meeting. Members, please note that since the last meeting altogether, the Secretariat has issued 3 information papers for members' reference. The first one is information paper entitled Proposal to extend the upper age limit for Category C security personnel permit provided by the administration. At the same time, I have also received letters from Mr. Duncan CHIU and Dr. Johnny NG, respectively. The first letter relates to a discussion on issues relating to the legislation on data security, and the second relates to the protection of government information systems and data. I have forwarded these 2 letters to members, and that in the second half of 2022, we will be discussing enactment of cybersecurity legislation, and we will discuss these 2 suggestions in one go. Dr. Johnny NG made the suggestion in his letter, which could be related to the panel on information technology and broadcasting. He has suggested that a joint meeting be held, and I have already forwarded his letter to the relevant panel clerk to follow up on the suggestion. In relation to the information paper provided by the administration on proposal to extend the upper age limit for Category C security personnel permit on the 9th of March, at the deadline at 5 p.m. on the 16th of March, the Secretariat has not received any comment on the information paper. So, as proposed in the paper, the Secretary for Security will be moving a resolution in the second quarter of this legislative year in accordance with the Security and Guarding Services Ordinance for the Legislative Council to approve the revised criteria. If there are no further comments, then the next item is items for discussion at the next meeting. Would members please refer to the list of outstanding items for discussion? The administration proposes to discuss 3 items at the next meeting to be held on the 3rd of May, Tuesday at 2:30 p.m. Now, the first item is proposed upgrading and creation of directorate posts and a report on the grade structure review for the discipline services and the proposed creation of a deputy chief fire officer time-limited post in fire services department. So that's the first proposed item. Second, proposed developments and implementation of the advanced passenger information system. Third item, smart customs information technology infrastructure. These 3 items relate to creation of posts and funding proposals. So other members of the council will be invited to join the discussion of these items. So if there are no further questions, I propose that we discuss these 3 items at the next meeting on the 3rd of May. So third item for today, that is the proposed creation of 1 senior assistant director and 1 assistant director supernumerary post in the Independent Commission Against Corruption. This is a staffing proposal and all members of the council have been invited to join the discussion. And may I first remind members that in all fairness, if you want to speak in relation to this item, please use the raise hand function in Zoom. Please just put down your hands first. I think the Secretariat already cleared the hands. I'll count to 3 and then you can press the raise hand key. I see a number of members. We do have a long agenda today. So if you do want to speak, please raise your hand as quickly as possible so that I know where to draw the line and allocate speaking time limits. And let me remind members that in accordance with Rule 83A of the Rules of Procedure, if you have any direct or indirect pecuniary interest in relating to the item being discussed, please disclose the nature of the interest before you speak. I now invite the Commissioner, Mr. Simon Pei, to deliver his opening remarks, and then I will throw open the floor. Good morning, Chairman. We're here today to discuss a staffing proposal in relation to support to be provided to me as President of the International Association of Anti-Corruption Authorities. Members are welcome to provide views on the proposal. There are three main points of the staffing proposals. First, we propose to create a supernumerary post of Senior Assistant Director, Commission Against Corruption, pitched at IPS 0.47, designated as Director of International Cooperation and Corporate Services for 3 years, and accordingly, another supernumerary post will be created. That is a post of Assistant Director, Commission Against Corruption, pitched at IPS 0.46 or D2, designated as Assistant Director, International Cooperation for 3 years. And we also propose to regrade one permanent secretary to the CAC post to Assistant Director by creating a permanent post and delete the permanent secretary to the CAC post. Both posts are pitched at IPS 0.46. With the approval of the Central People's Government and the Chief Executive of the Hong Kong SAR, I ran for the presidency of the IAACA and was successfully elected president at this general meeting on the 5th of January. The presidency commenced immediately for 3 years. The IAACA is an independent anti-corruption organization comprising anti-corruption institutions around the world. The objective is to promote effective implementation of the United Nations Convention Against Corruption, foster constructive collaboration to fight against corruption. There is a need to set up a secretariat to support me as president of the IAACA. According to overseas experience, the most senior officials, such as the Secretary General, will be deputized to take part in the related activities of the IAACA. And that is why we need a properly pitched post, and that is a D3 post, to take up this title as Director of International Cooperation and Corporate Services, so that he can be the Secretary General of IAACA, and if necessary, he can be deputized and hold relevant meetings and hold discussions on my behalf, and also on the international platform, share with overseas counterparts our anti-corruption experience. We have 3 D3 posts at the moment. They are they are respectively Deputy Director of Operations, also the Director of Corruption Prevention and Community Relations Department. To accurately reflect the unique nature of work in relation to international cooperation, we propose to create a post pitched at D3, and that is a supernumerary post of Senior Assistant Director. The Director of International Cooperation and Corporate Services, in other words. Also, to support my post as President of the IAACA, there is a need to create the post of Assistant Director International Cooperation, which is a supernumerary post for 3 years. He will be providing support to the Director of International Cooperation and Corporate Services, as well as spearheading training activities and liaison with overseas counterparts. For example, we provide training and capacity enhancement for Belt and Road countries, and we also work with relevant counterparts in the Greater Bay Area and provide anti-corruption consultancy services. There are also currently 2 D2 ranks in ICAC, and namely Assistant Director CAC and Secretary to the CAC. The former post of Assistant Director Administration was the only post pitching at this rank to advise the Commissioner, and that is myself, on relevant matters. Following the establishment of International Cooperation and Corporate Services Division, this role will be taken up by the DIC, that is Director, and that is more appropriate to regrade the post as an Assistant Director CAC from the formerly administration branch. So our proposal is to regrade the Permanent Secretary to the CAC post to Assistant Director CAC post. These 2 posts are both pitched at D2 level, so no additional costs will be involved. So much from me on the relevant staffing proposals. I'll be happy to take questions from members. Thank you. Thank you, Commissioner. We do have a long agenda today, members. So if you want to speak, please indicate as quickly as possible. We have Mr. Edmund Wong, Mr. Dr Hon CHIU, Ronick Chen, Lai Tong Kwok, Elizabeth Quartz, and Mr. Lam Sen Kong. 7 members. Anyone else? I'll draw a line here. Mr. Edmund Wong, you'll be the first to speak, and each member will be given 3 minutes speaking time limit. Thank you, Chairman. Thank you, Commissioner. Well, I think your presidency of IAACA is an achievement of the ICAC and the work in Hong Kong. I understand you do have a heavy workload and that you must do your best. So I strongly support the creation of these posts. But apart from the supernumerary posts, according to the paper, you have 180 non-directorate posts in the ICD. So my question for the Commissioner is this: among the 180 non-directorate posts, how many of them are deployed through internal transfer, and how many are new recruits? What about the total cost of the 180 strong establishment? I don't think this is mentioned in the paper. So could you please give us some details? The former president of IACA is one from Qatar, and the term of office was 6 years. Do you have any idea how much was involved? And for the first president, the president came from the mainland, and then for the second and third presidents, they both came from Qatar. So after the term of 6 years have lapsed, what will happen? Can you tell us more, Commissioner? I don't think we have made it very clear in the paper indeed. In fact, the new Senior Assistant Director will take charge of 2 portfolios. One is on corporate services. We do have a corporate services branch or division with an establishment of over 100. They are in charge of matters relating to corporate services. The post title was formerly Assistant Director Administration. Now we have the new title, Assistant Director Corporate Services. For the newly created post, the establishment is limited. Apart from the 2 proposed supernumerary posts, directorate posts, the division has been assigned some non-directorate posts, and this will also be underpinned by some other colleagues through internal transfer. So not all 180 posts are newly created. I would defer to my colleague to explain.
And as for Qatar, with their 5 years term of chairmanship, how much expenses was actually incurred? First of all, I haven't learned that from them, and I haven't asked them. And whether they will provide me the answer if I should ask, I do not know. Now, also in the constitution of the organization, it doesn't say as to how many terms the chairman can be in position for. And for every changeover of the chairmanship, there are specific reasons for that. And that is the presidency role of the IAACA. So I cannot say as to what should happen then. As for the shifting of manpower, should the term end, we will make the relevant adjustments so that these posts, these supernumerary posts, will not be in limbo at all. Now, Commissioner, because time is up, can you please note down the question from the members, and in the Human Resources panel, we can perhaps follow up on this question. Yes, Mr. Tang. Thank you, Mr. Chair, and thank you, Commissioner. I think Hong Kong's role and its international renown for combating corruption is very high indeed. But it seems that the Western powers are using all means to trample on the advantages of Hong Kong, or the position of Hong Kong in anti-corruption and in other regards. We can already see what's happening in the past couple of days in the courts. And I think it is an honor for us to be in the position of the presidency of the International Association of Anti-Corruption Authorities. My question to you is, how would this help in promoting our position in international arena in anti-corruption with this presidency? And secondly, in terms of expenses with these roles, these positions, are there KPIs with the millions of dollars that we will be spending on this? If the commissioner can give us the benefits of such expenses, if we should incur them. Mr. Commissioner. Chair, first of all, this organization is a non-political one. And basically, it is about cooperation of international anti-corruption efforts. And as you know, there is a convention of the UN for anti-corruption, and there are 180 signatories to that. And how do we coordinate the anti-corruption authorities within these 180 plus states to combat internationally corruption and bribery? Well, that would be one of the terms of references of this international organization, the IAACA. Now, after I have been elected to the presidency, I see that recently there is an international rating agency which had raised the rating of this of our organization, and that is Hong Kong, after taking up the presidency, is something positive, not only for Hong Kong, but internationally. Now, I have been elected for about 2 months or so. So far, I have not seen any state or organization to attack Hong Kong in any way because of this. But of course, we will be very careful about this. Secondly, about the KPI. Upon ascending the presidency, I have done something new. First of all, I have put the states into 5 regions internationally, and for each region, there is a vice chair to lead the executive committees to promote and to forward coordination in anti-corruption capabilities within the region to provide training, etc. And I think with this, going forward for international anti-corruption efforts, the International Association will be even more capable. Yes, we will have Mr. Chen Chunying and then Mr. Lai. First of all, declaration of interest. I am an consultant or advisory committee member of the ICAC. First of all, I observe that I'm in support of this in principle because to step up with our anti-corruption profile and efforts, it is good. My question is that for the detailed responsibilities of the 8 director grade staff, if possible in the relevant panel, you can give us the details. I have 3 questions to ask. First of all, as mentioned by another colleague, how will these positions be filled? For instance, would there be promotions within the ICAC, or will the position be filled from outside? Now, as for the supernumerary roles, whether it is 6 years or whatever, after that, I would like to say in terms of succession for the directorate pros within the ICAC, had that been planned already? For the non-directorate positions, after 3 or 6 years of anti-corruption authorities internationally, how can their experience and capabilities be well utilized within the organization, please? As a commission? No? Well, first of all, for the non-directorate positions duties, yes, we can definitely in the HR panel provide for that. And secondly, in the International Association of Anti-Corruption Authorities, IACA, I have been within the IXCO for over 10 years, and we have staff following up with the work, and we have also taken up with the Belt and Road regions training. And this time, we are consolidating staff from the different areas of service, and internally to the ICAC, especially those staff that have been responsible for relevant work, we will be looking for filling of the positions from them. And also from other sections or departments, we may second them for short-term or long-term for help in this work. And also we will be recruiting from outside as well. We will need staff who would be familiar with the foreign languages, because this is an international organization. We will have to step up and or strengthen our foreign languages capabilities. As for the supernumerary roles after the ICAC, that is myself, the commissioner is no longer the president, as I've mentioned in my answer to Mr. Wong. Whether it is a 3-year term or 6-year term or even longer after it has elapsed, we will definitely be very cognizant and monitor the situation of the redeployment of the staff concerned. Thank you, Chair. In assumption of presidency of the IAACA, it reflects that the work of the ICAC is recognized internationally, and that is a very good thing. The Secretariat of the General Secretary and Mr. Jia Chun Wang of the China Supreme People's Prosecution Court had been in this for the position for a long time. And the ICAC right now, there are 20 positions which are handling the relevant work, and then they are directly coming under the supervision of the assistant director. I just want to clarify, as far as I understanding, that there are 2 directorates to be new positions opened this round, and there are 8 others that are non-directorate grade staff. So this is the situation. And in setting up this secretariat, I'm in support of this 3-year proposed 2 supernumerary directorate posts to support the commissioner in the work. And in paragraph 7 there, it says that the attending of international events right now is not really ideal. So there will need to be a representation of the commissioner to liaise and have meetings with the heads of the ACAs and international organizations. And officers at D3 level is therefore absolutely necessary for sharing out the burden of the commissioner and to deputize him on high-level international and mainland forums. And this, Mr. Tang had mentioned, that is the KPI and the detailed items of duty. We need information of that. And it says that it is a proposed 2 supernumerary directorate posts that it's needed, but if the commissioner can give us the workload for the secretariat, as far as you know, that would be necessary information for us to consider. And also after the 3-year term, will there be a reversion to the original organization structure? And these 2 new posts, will there be how will they be handled, please? The Commissioner, because of the limit of time, perhaps for further information, if you can provide that under HR, Human Resources, that would be good. If you can respond to the other questions, please. Thank you, Chair. The 2 previous presidents, that is China, our country, and also Qatar, indeed their secretariats in terms of their workload and their human resources and manpower, we do not have detailed information of that. And it is up to the current president to deploy as he sees fit. Well, actually, after the election to the presidency, even though it's just been a short 2 to 3 months, we have done a huge amount of work. We had to contact all 180 plus signatories and the anti-corruption authorities under them. Some of the states have 2 or even 3 such authorities. We had to do liaison work. And as mentioned, I have provided for, or I have directed that there should be 5 regions to be demarcated internationally. And each region will have its own coordination work, and we need to coordinate with these 5 regions separately. So that is a huge amount of work as well. From what I can observe in the past 2 and some months, it's I can totally see this. And I would say in projecting into the future, the workload is based on that observation. And on that observation, I'm proposing that we need these additional positions. Ma Fung Kwok, please. Ma Fung Kwok, please unmute yourself. Thank you, Chair. I would like to take this opportunity, Chair, to congratulate the Commissioner in being elected the President of the IAACA. Apart from his personal efforts and performance, the performance of the ICAC of Hong Kong is definitely given international recognition. And I'm sure it also means that the central government had been giving it staunch support and promotion. Now, this is an authority that comes under the United Nations, as the Commissioner had mentioned. I'm not familiar with the work of this IAACA. I would like to know whether the UN will be providing resources to us, or the central government would be providing resources to us in terms of manpower or finance to support the work of the Secretariat, because I think that this is important. I too want that the IAACA, under the new leadership of our commissioner, will have more contribution to international anti-corruption work.
So I do hope that with your leadership, the IAACA will be able to excel, and I personally support you. In terms of resources, can I have more information about, say, the structure and the source of funding, and whether we're required to pay, for example, a membership fee, and something more about membership in general. The other question is this: the commissioner mentioned that he ran for the presidency. That means the election was contested and he managed to garner support. So, Commissioner, what is your vision in the coming 3 years? Can you explain to us your work for the IAACA and the goals you wish to achieve? Thank you, Chairman. The IAACA is not a UN organization per se. In 2006, when the United Nations Convention Against Corruption was enacted, our country initiated and set up this IAACA. It's an international organization, but it is not under the United Nations. We're not allocated any funding, hence. The then president and the country to which the president belonged will be responsible for the fees and costs involved. No membership fee is charged. And the country of the president will be responsible for the overheads. Each presidency runs for 3 years before another election comes along. We understand that the last president did not want to extend his term. So we applied for approval from the Central People's Government to run for the presidency of the organization. And I was elected. All these years, we've been a member of the executive committee of the IAACA. And for years, we've also been the convener of the training group providing global training under the IAACA. And as I explained just now, I've divided the countries of the world into 5 categories. And that chairman of each group is delegated the task to provide training for these countries with a view to enhancing their anti-graft capability in order to achieve the goal set under the United Nations Convention Against Corruption, that is to fight against corruption. Next, Ms. Elizabeth Quat and Mr. Lamson Krong, please get yourself ready. Ms. Quat. Thank you, Chairman. First of all, I congratulate the Commissioner for winning the presidency of the IAACA for a term of 3 years. This is a recognition of your caliber, as well as recognition of our anti-corruption work in Hong Kong. A lot has been done for the organization, and I think we've been briefed the work of the ICAC before. But for general public, I don't think they have a clear understanding of the work. So by creating these two posts, you'll be able to explain better to the public the hierarchy or the structure of the association, and that a lot of resources and manpower will be needed. So for your establishment, in particular, the two supernumerary posts to be created, they'll be able to get a lot of invaluable experience. Meanwhile, this is one way to let the public know the role of the ICAC and the commissioner in IAACA, our contribution in fighting corruption globally. And you should tell us whether you take a but very different approach in fighting corruption in IAACA, and I do hope your term of office will not be limited to 3 years. At the same time, I have a question about these supernumerary posts and their future prospect once your presidency ends, and whether they can bring more contribution to fighting corruption. So I support this proposal, Chairman, and in the establishment subcommittee's paper, I hope the ICAC will give us a more detailed account of the work involved and contribution to the global community as well as Hong Kong, and they should also give regular updates to us. Any response from you, Commissioner? Yes, very briefly, this will definitely benefit Hong Kong. As I explained just now, some rating agencies have already raised our rating. In terms of anti-corruption work on the international stage, will definitely this will definitely help raise our profile. This is an international organization, meaning that we have strong liaison with overseas anti-graft agencies, and this will also be an eye-opening experience as we liaise more often with our overseas counterparts. So this will definitely benefit us as well. As for other information, I think I'll include them in the establishment subcommittee paper. Last member to speak, Mr. Lamson Kerr. Thank you, Chairman. Well, basically, Mr. Tan CHIU already covered the points I wish to make. I think KPI is a very familiar task for all of us. Is a gauge to assess the benefits of any commercial organization. I hope the commissioner will give us some more detailed account so that over time we will have a better idea of the benefits that will be brought about. So I'd like to know more, Commissioner. Any response? Very briefly, we have regular updates issued by bulletins, and this will be circulated to members and it will be uploaded to the internet as well. This will help electrical members understand our work. At the same time, I can attend panel briefings and also level with the public through the media so that they have a better idea of the work and achievements of the IACA. Right, members. 7 members have already spoken, and I haven't heard any objection to the proposed creation of these 2 posts. So if there is no objection, I suggest we submit this paper to the establishment subcommittee for further discussion. All right, Commissioner, please take note of the points raised by members such as KPI and the future staffing arrangements at the end of your presidency, and also relevant expenditure involved in previous precedents. Next item, an update on the handling of non-refoulement claims and the related staffing proposals. Again, this is a staffing proposal and all members of the council have been invited to take part in the discussion of this item. I will first invite my staff to remove the hands first, and if you want to speak, use the raise hand function now. With us today, we have Mr. Sunny Au, Under Secretary for Security, Deputy Director of Immigration, Mr. Benson Kwok. We do have other officers in attendance. Their names will be called if they're required to speak. So, Mr. Au, if you're ready. Chairman, the Security Bureau proposes to retain a supernumerary post of Assistant Director of the Removal Assessment and Litigation Branch for 3 years, and to upgrade the permanent post of Principal Immigration Officer to the rank of Senior Principal Officer under the Enforcement Branch. For the first proposal in 2016, a comprehensive review was conducted by the government, and so far we have achieved progress in improving the strategy of handling non-refoulement claims. For example, the time needed to process a claim has been reduced from 25 weeks to 10 weeks. That is 60% reduction. And basically, in early 2022, we will be able to clear the backlog of claims. The processing of claims were affected by COVID-19 epidemic, and meanwhile, there was a surge in the number of claims. So at the time, the new claims pending screening rebounded to about 1,500 last year. However, with our efforts, the number of claims pending screening have been brought down to about 400. We do envisage a number of challenges. For example, we're unable to fully address the issue of prompt removal. The Immigration Department will be required to implement the various initiatives under the comprehensive review, especially the improvement measures under the Immigration Amendment Ordinance 2021. The Bureau therefore proposes to retain the supernumerary post of Assistant Director of Immigration so as to ensure consistency and smooth operation of the unified screening mechanism and expedite the removal process. As for the second proposal, the enforcement branch under the Immigration Department is responsible for investigation, prosecution, detention, and as well as removal and deportation. And the counterterrorism division was also set up under the enforcement branch. With increasing complexity of our work, we have continued to expand the establishment. As for the principal immigration officer, the work entailed also increases in complexity and quantity. That is why we propose to upgrade this permanent post to the rank of Senior Principal Immigration Officer so that he can provide support to the Director of Immigration in enhancing management and take new enforcement initiatives. Details of these two proposals are set out in the paper. With members' support, we will submit the application to the Establishment Subcommittee. Thank you, Chairman, and we are happy to take questions from members. Thank you, Undersecretary. 12 members would like to speak according to the Secretariat. And if you want to speak, please press the button now. Otherwise, I'll draw a line at 12. 12 members. Let me read out the order. Dominic Lee, Dr. Chao Kwong, Elizabeth Quad, Edmund Wong, Frankie Yik, Chen Kin-po, Maggie Chan, Johnny Ng, Ronick Chen, Tang Ha Bill, Chen Ho Yan, and Deputy Chair Lai Tong Kwok. We start with Mr. Dominic Lee, 4 minutes.
Thank you very much, Chair. False refugees had greatly adversely affected the finances of Hong Kong and also grave criminal offenses, robberies, rapes, etc., etc. And for the backlog or cases waiting for screening is over 455 cases. And there are 2,600 cases which are pending processing. And therefore, I'm in support of this position of retaining the supernumerary post of assistant director and upgrading one permanent post of principal immigration officer. I'm in support of that. For these false refugees, there seem to be more an upward trend of subsequent claim. And there were only 50 requests received in 2018 and 116 in 2019, 446 in 2020, and further to 510 in 2021. Why is this a situation? And concerning this, what are the responses and measures from the authorities concerned? Now, I'm very concerned for these false refugees where their petition or claim is refused. They continue to try to stay in Hong Kong and they are not removed. And the number of these persons are huge. Now, it seems that you're not able to solve that as a problem, as a question. And I see that they are basically just abusing our legal system. What is your response to that? And will you be asking the central government to exclude Hong Kong from the convention? Or would you be setting up closed camps for these persons? Well, thank you very much, Mr. Lee, for the questions. First of all, just to thank Mr. Lee in supporting the request for retaining the supernumerary post and upgrading the permanent post of PIO. Now, in the past period of time, we have received 1,353 subsequent claims requests, and we have reviewed 778 cases. And among them, and Mr. Lee had mentioned, as Mr. Lee had mentioned, there had been certain claims to the tune of 322 cases asking for JR judicial review. And the courts have expedited the process. 250 cases had already been dealt with, and within these 250 cases, there had been 222 cases of refusals right after the court proceedings. And also the High Court Ordinance, Article 27, which says without court approval, there cannot be any further requests to the court. So as for JR judicial review, the judiciary has already done a huge amount of work to increase the speed of the proceedings. In a number of cases, we see that the courts have actually, they have already processed over 4,000 cases. And in the final court and also in the appeals court, there have been many cases handled. And further, there had been more judges appointed to the final court, and for the appeals court, only 2 judges need to sit on the appeals court. Because of time, perhaps I will just close my answer here. Yes, first of all, Mr. Chow, Dr. Chow. Thank you, Chair. Concerning the removal of such persons, it has plagued Hong Kong for a long time, and we do want there to be a resolution, and it would indeed cut the crime rate for Hong Kong. And therefore, given that, I am in support of the proposal from the Immigration Department. Now, just now, it's been mentioned in the progress, there are 450 plus cases remaining on hand. Will you be able to reduce the number to 0 for those pending screening, or drastically reduce them? Now, actually crossing the boundary these days is already difficult enough. So do you think that you will be able to resolve this soon? For example, reviewing the immigration policies, or to provide early provision of travelers' information? And what about the Convention for International Aviation? Is there any room under those to help resolve the situation? And also for illegal immigrants, what measures have you to reduce IIs in Hong Kong? And just now, Mr. Lee, my colleague, suggested a closed camp for such persons. I am in support of that idea. We have all these special facilities constructed recently. Can these be deployed for at some point in the future for the retention of such persons, so as to help us expedite and resolve the issues and problems we have on hand? Chair, concerning Dr. Chow's questions, I will answer those questions, and then my colleague will supplement. For the 400 plus cases, we have already been speeding up the process. The 25 weeks processing time for each case had been drastically reduced to 10 weeks or so. The 400 plus cases we have on hand, if there are no new ones, we should be able to, within a very short period of time, reduce those to a low number of cases. But COVID, of course, is a factor. Our Immigration Department colleagues, and for legal aid lawyers, for instance, it would affect their work as well. So the COVID situation is relevant. Where there is a resumption of some normality, the speed of processing these cases will pick up again. Now, Dr. Chow mentioned just now concerning the early arrangement concerning aviation. We are working hard on that. And we will be coming to the panel for reports and also for requests for funding. Now, the Immigration Department and the police had been working together with the immigration departments and the police in the mainland, the central government, and under the different provinces. We have been working and cooperating with them. Now, for illegal immigrants, there are half which are illegal immigrants, and those who claim to be refugees. There had been lowering of such numbers. For IIs, there is a 35% decrease, and 60% which are exceeding the stay. As for closed camps, we have already discussed that before, because Hong Kong does have a lack of land. If we are to find the relevant land to set up closed camps to house 14,000 persons, it would be difficult. But for the persons which pose danger for the security of Hong Kong, we would want to, first of all, utilize our resources wisely, and also we will be looking for the resources to handle these persons. Ms. Kwok, please, and then Mr. Wong. Ms. Kwok? For false refugees issue, it had really plagued Hong Kong for a long number of years. And in the past years of cases, Hong Kong had used some 7 billion or 8 billion cumulatively on these cases. And lately, it's been another billion that have been dedicated to such cases. And it had posed a very big threat to our safety and security in Hong Kong. Now, I do see that the claimants are reducing in terms of numbers, but again, I still see 455 cases which are pending screening and 2,000 plus cases are in the appeal stage. Now, for these new cases, what are they? What is the nature? Are they locals? Are they illegal immigrants? Are they perhaps foreign domestic helpers who are overstaying? I would like to know. Now, I also see that there are 14,800 cases which are still in Hong Kong, and the Immigration Department had already ruled them as unqualified, but nevertheless, they are still staying in Hong Kong. So how will these people be dealt with? And 7,769 of them had applied for JR, and we do see abuse of our legal and judicial proceedings. And this is a grave problem. Now, just now, it's been already mentioned that there is efforts to work with the DOJ concerning subsequent claim requests. It seems that it is effective to a certain extent, but what about the 7,700 plus cases of JR cases? Can we also use this methodology to handle those cases? Thank you, Ms. Kwok, for the question. In handling the claims, I think Ms. Kwok knows the situation well, and we thank Ms. Kwok in chairing certain meetings to discuss and resolve some of the issues, including the 2021 bills and law amendments. Now, concerning the information of the claimants and the cases, in the 2021 figures, we have 2,528 request cases, of which 95% are from South Asia and Southeast Asian countries. Vietnam is 31% and Indonesia as well, 31%. Philippines is 11%. In these requests, II would be 40% or so. Well, just now I said 30%, I think. The proportion of IIs, it's actually 40%. And overstaying is 20%. So this is different. In the past, it was 50-50 for the two. So that's changed. And for the other questions, perhaps Mr. Kwok, Deputy Director, can answer the other questions. Thank you, Dr. Chow, for the question, Ms. Kwok, for the questions. Concerning the recent trend, domestic helpers, there had been more cases coming from them. And this, for the other cases, perhaps it has to, for this increase, it may be because we have stepped up with the Immigration Department had stepped up with actions against unlawful changing of jobs. And therefore, they have tried to stay in Hong Kong or exceed their stay in Hong Kong by resorting to these applications or refoulement claims. Ms. Kwok, your time is up. If you have any follow-up questions, perhaps after the meeting, you can ask the authorities for the relevant information, including the statistics. Well, thank you, Chair. Thank you for the information. Yes, using the retention of supernumerary posts and upgrading of posts to combat this issue, I'm in support of that. At the same time, we hope that there can be a streamlining of the structure within the immigration department to deal with the cases. And I do see that there is an upward trend of subsequent claim requests, and there would be at times cases resorting to JR to prolong the illegal stay in Hong Kong. I heard from the previous answer that for JR claims, it's been reduced from 25 weeks to about 10 weeks. Are there further measures you can put into place to reduce the expenses and public monies dedicated to the handling of these cases, these false refugee cases? And what about reducing the time of overstay in Hong Kong for such cases? I know that the authorities have been trying their best to combat such situation and cases, but using this mechanism, statutory mechanism and judicial procedures to achieve their ends, and also people showing the way for so doing. I hope the immigration department can do something about that. And as for the Cheung Sha Wan facilities, as the detention centers, there had been certain deaths. In February, there was a mainlander who committed suicide, and last year in November, there was a person of India, Indian person who had passed out in the camp. So can you tell us how you will be able to reduce such cases or to avoid having the recurrence of such cases? Thank you, Chair. First of all, for Mr. Wong's question.
On enforcement, assessment, or screening, my response is that on average, it takes about 10 weeks, and we strive to shorten the time for screening and assessment. We need to abide by the court's principles of fairness and impartiality. And meanwhile, we don't want any delay tactics. And we're grateful to members for passing the Immigration Amendment Ordinance last year to help us address issues of deliberate delays. On enforcement, the Immigration Department takes this approach. We have stepped up enforcement efforts against illegal immigrants and overstayers. This can be seen through the prosecution figures and the courts, for example, have also raised the starting point of sentencing. Now let me give you an example. Previously, the tariff was only a few months. Now it's been raised to close to a year. For employing illegal workers, the imprisonment penalty has been raised to 15 months. On the Castle Peak Bay Immigration Center, or CIC, I'll defer to my colleague. We have been attaching importance to ensuring the health of our prisoners, and we have a medical panel providing healthcare services to detainees. And if need be, our doctors will send prisoners to hospitals for checkups and for treatment if necessary. As for self-harm or suicide cases, our staff receive relevant training on a regular basis on preventing self-harm or acts of self-harm or suicide in detention centers. We also have guidelines in this regard. Should such an unfortunate incident happen, Our medical officers will assess the physical and mental condition of the detainee to prevent tragedies from happening. Next, Mr. Chen Kin-po, to be followed by Ms. Maggie Chan. The annex sets out the progress achieved since the implementation of the comprehensive review of the unified screening mechanism in 2016. It's encouraging. It seems that issues that have been raised by members over the years have now been addressed. However, the modus operandi also evolves with these new strategies. They play delaying tactics, repeated judicial review applications, for example. We now work with one heart. It's not difficult to amend legislation. So may I know whether our legislation needs to be amended so that we can be more effective in tackling these non-refoulement claimants, because they lead to increase in crimes and causing nuisance to our people. The second question is to pick up on Ms. Elizabeth Quat's point. You have over 7,000 JR applications. Are you going to work with the Department of Justice and draw up a strategy to tackle the issue? How are you going to clear the backlog despite the drop in the number of new applications? Undersecretary. Thank you, Chairman. Thank you, Mr. Chan. It's true that things are constantly evolving, including the modus operandi of these applicants. And we try to detect whether there are loopholes to prevent them from exploiting them in delaying their stay in Hong Kong. That is why I appeal to members to pass the resolution, which we will be moving to retain the supernumerary post for another 3 years. It is very important. We need experienced personnel in the immigration department. They are familiar with the legislation and they have the experience, and this is effective in tackling the abuse. For those who abuse the USM mechanism or court proceedings, concerted efforts are required to tackle them. This is not just about the unified screening mechanism. We also need to work with, for example, the enforcement agency as well as the Department of Justice. Now, in terms of court proceedings, as you can see in the paper, when it is apparent that the litigant is abusing the court procedure, an application will be made under Section 27, Chapter 3 of the High Court Ordinance to bar the litigant from making repeated applications. We have 250 applications in which, in fact, it's 222 cases out of that number in which the High Court has already made an order, and that is followed by immediate deportation of the applicants. About the 7,000 cases in a backlog, they've gone through the judicial review procedure. For these JR cases, the judiciary has expedited the proceedings with increased manpower. And I think members are familiar with it. It is hoped that by taking this multi-pronged strategy, we'll be able to tackle the problem more effectively. So we appeal to members' support so that this Assistant Director supernumerary post can be retained for 3 years. Yes, I support that. Ms. Maggie Chan and then Dr. Johnny NG. Ms. Chan. Thank you, Chairman. Well, this proposal is about retaining and upgrading posts respectively, and the public money is involved. I think the administration should address the issue of bogus refugees as quickly as possible. We're talking about several dozen $1 million a year if you create a directorate post. We find it just. However, What about the expenditure on tackling bogus refugees? According to Oriental Daily, the article refers to the fact that $6 billion have been spent over 7 years. Now, the headline reads, bogus refugees overstaying in Hong Kong is a waste of resources. So, may I know more about the $6 billion expenditure? Is it on publicly funded legal assistance, humanitarian support, or what? It accounts for 70% of all the expenses. I don't have problem with the staffing proposal of the immigration department, but taking a value for money perspective, can you tell us more? If you have more posts, will you be able to expedite the removal procedure? And how cost effective is it? What is the savings involved in terms of tackling bogus refugees? Do you have these figures? And the secretary. Chairman, now to take Ms. Chan's question on this issue, let me cite some figures. There are 445 cases pending screening, and then we have 2,662 cases at the appeal level. And with increase in manpower and in legal aid, we believe that we'll be able to expedite the procedure. Now, as mentioned just now, the judiciary has expedited the procedure, and we hope to achieve better progress. Now, there are also issues with flights, and there are also detainees being imprisoned. They're serving a sentence. Now, about the expenditure, as mentioned by Ms. Chen, let's make a comparison. In 2020, 2021, and 2021-22, for the first year, we spent $900 million, and then second year, about $1 billion. The breakdown is as follows. On screening appeal at the level of immigration department, that is, we have an appeal board and a screening mechanism, and then the next procedure, removal. And publicly funded legal assistance is available. That's the third area. The fourth is humanitarian support, and that is when claimants stay in Hong Kong, they'll be provided with basic necessities such as food and rental allowance. So how do we cut costs? Different departments have looked into these expenses. These are necessary expenses. The best way to save costs is to speed up the removal process. Once they're deported, you don't need to spend that much. So if you have a drop in the number of new claims and a rise in the number of persons removed, we'll be able to cut costs. But of course, we need sufficient manpower. That is why the post of Assistant Director of Immigration is important, so that he can help smoothen things out in different areas. Next, Dr. Johnny Ng, and then Mr. Ronick Chan. Thank you, Chairman. First of all, I thank the Bureau and the Department for your ongoing effort in tackling this issue. I also support this staffing proposal. The problem is we have over 10,000 claimants staying in Hong Kong. They're only given basic allowances. They live in undesirable conditions. And when the epidemic situation is dire, what assistance will be provided to these claimants if should they be infected with COVID-19? Will there be isolation facilities available so that they don't become the floodgate of cases? Thank you for your comment. In relation to claimants overstayed in Hong Kong, there are applicable anti-epidemic measures on 3 fronts. First, the Security Bureau, as well as the departments under the Bureau, implement certain measures. You may have read from the news that the Security Bureau has set up an anti-epidemic task force responsible for management of isolation facilities, as well as providing support to the confinees. And we also serve non-ethnic minorities, including these claimants. For the mobile field hospital in Hon Duncan CHIU, we set up a dedicated area for non-ethnic ethnic minorities. At its peak, we received about 200 ethnic minorities in the mobile field hospital.
Apart from that, we have also hired certain racial minority individuals on contract basis to help explain some of the measures so that the relevant people do not need to be overly worried or feel anxious. Now, apart from that, the Fire Services Department had set up a hotline, and this hotline is equipped with 8 different languages. It is also on Facebook as well, to provide information on the epidemic and where it is necessary for the cases to be moved to the Hon Duncan CHIU facilities, and also where COVID is contracted, what to do. And also at the DO's district offices and also the district police, they also are in contact with the racial minorities to provide COVID prevention information, and also the importance of vaccination. And of course, these claimants are included in our vaccination program. Starting tomorrow in all the different districts, we will be distributing the COVID combat resource kit. And I see that a number of members here are also modeling this, physically helping with distributing resource kits and also food to the people of Hong Kong. And for that, we are very thankful to members. And also at the district level, at the different centers, there are also NGOs, etc., which are providing the resources and the packages to the racial minority. At the same time, we are in contact with the consulates in Hong Kong, where they know that their nationals in Hong Kong have certain needs. They would inform us. So that is the kind of work we have been doing in the past. Mr. Ronick Chan, please. Thank you, Chair. First of all, declaration of interest. I'm a member of the pilot scheme for legal advice for the overstay cases. Now, first of all, I'm in full support of these 2 positions to combat the issues we have. And my question is, after 3 years, what then? When the this supernumerary post and the permanent post had, or the supernumerary post had expired in its tenure. Because I do see that this assistant director is about supporting enforcement. And I think that that is important. It is necessary work. And in the paper, it talks about his responsibilities on IIs and also false marriages and also trafficking, etc. The paper is very clear in describing all those areas of work. And then there are employers employing illegal immigrants and also combat of crimes. I see that in the paper, it is relatively less in terms of coverage of these two areas of work. Now, my question is that where these two positions are put into place, how they can help with combating these bogus refugees issues, in particular in these two areas. Yes, I will respond to Mr. Chan on the question, and then my colleague will supplement. First of all, we thank Mr. Chan for the support. Concerning the Assistant Director of Immigration, you have asked questions about illegal employment and crimes, including online crimes. Now, for the former, for illegal employment, there had been 9,000, and last year, 12,000 such cases which have been handled. Arrests for non-Chinese illegal immigrants, arrests, it was 544 arrests last year. It was 300 the year before. And illegal employment for employers, it was 289 who have been prosecuted. And we have also strengthened the relevant clauses in the ordinance. And that is, under the ordinance, we are able to prosecute the employers as well. And over 60 of such cases had been prosecuted, and there had been incarceration of 8 months to 12 months. And the employers had also, under the new amended ordinance, it could attract a longer incarceration or imprisonment duration as well. So it has been strengthened. Now, for immigration crimes, there had been more of such crimes, and therefore it had been set up a special unit for targeting and combating relevant crimes, including false marriages. Now, because of time, can you be succinct in your response? That's right. In law enforcement, well, actually, I think my colleague, Mr. Chen Wei-Yip, can respond to that. Yes, especially for online crime. In 2021, there was a dedicated task force targeting online crimes and to prevent online crimes, so that the criminal elements cannot use the internet to perpetrate the crimes. And the task force had needed to appear in the court as witnesses and also keep up with the trend of online crimes, and also equip ourselves with the relevant skills to combat internet-based crimes. And since the setup of this task force, there had been 12 cases dealt with, and there had been 16 mobile phones and all sorts of data and memory chips, etc., which had been apprehended. And the data was over 1 TB. And there had been false certificates for illegal marriages, etc. And we will continue to carry out such work, and we will be using the relevant equipment and devices to combat such online crimes. Thank you. Mr. Tan CHIU next. Mr. Tan CHIU next. Yes, you have unmuted yourself. Thank you. Now, where there is any bills or amended ordinances to combat the false or bogus refugee cases, I welcome that. We can imagine that for the 14,000 cases still overstaying in Hong Kong, I'm sure some of them will be employed illegally. It is almost inevitable. Some of them are actually going to bars, buying drinks, and they have fancy clothes. Where does the money come from? So we need to definitely combat the cases as soon as possible. But we've been talking about this for over 10 years. It seems that the issue is still around us. Can the government be more clear as to if we exit from the Prevention of Torture Convention, how would that help to resolve the issue? That's the first question. A second question, for these bogus refugees or these claimants, during the interim, if they have already been, if they have committed certain crimes or had been prosecuted and there had been imprisonment judgment, for example, can we right away remove them and repatriate them? Because safety and security is important. Yes, two very straightforward questions. Right. Mr. Tang's first question about exiting the convention. For our human rights law, apart from the convention for prevention of torture, actually, we also have for our human rights legislation, it also says something that is similar to clause 3 of the convention, which means that a person has to be prevented from being put in a position or given penalties, including torture or humiliation, etc. So this is internal to us, internal to the Hong Kong laws. Just now, Mr. Tang suggested that where there is imprisonment terms of over 6 months, there should be repatriation right after. Well, in fact, the repatriation, for repatriation, we have to ascertain that after repatriation, the person will not be subject to torture or any violent treatment, and the courts will be the gatekeeper for that. And for any executive procedures, they will have to abide by the judgments and precedents set by the courts. Right. Next, Ms. Chairman Yan and our Vice Chairman. Thank you, Chair. The bogus refugees issue had always been a plague in Hong Kong. I remember there was a newspaper headline which says that in 7 years of the HKSAR, 6 billion Hong Kong dollars had been spent on these refugees. And this is like 6 blocks of public housing expenses. And it is creating pressure for our government departments so that we have to dedicate more public funding to create these additional posts. And the refugee problem is plaguing us because of COVID as well. Because of the special deployment of the civil service, they are going frontline, and there is a shortage of our manpower. And these claimants, some of them have been overstaying in Hong Kong because they cannot be processed or repatriated or removed in time. Well, these that cannot be repatriated in time, those that are staying in Hong Kong, they are providing a kind of economic pressure for Hong Kong as well. Now, it's been mentioned that there is a 14,800 cases concerned, and for the creation or retaining the supernumerary post and upgrading of the principal immigration officer, with these 2 actions, would we have sufficient manpower to tackle these overstaying issues successfully? And I see that half of these claimants are resorting to JR, even though you mentioned that the processing time had been reduced from 24 weeks to 10 weeks, but 10 weeks is still too long. How can you shorten that processing time for JR? Using a lot of public funding to combat these bogus IRs is an issue, but I think what we need to do is to tackle it at source. Perhaps this is ultra-virus for your department, but I think you should, the relevant authorities should trace the traffickers or those parties which are helping these illegal immigrants in arriving to Hong Kong step up with the actions there.
Undersecretary. Well, thank you, Mr. Chan, for supporting this item. This is very important because in order to address the issues raised by Ms. Chan, we really need an Assistant Director of Immigration with ample experience and familiar with the procedures. We talked about the figures relating to tackling illegal immigrants, especially for non-ethnic Chinese unauthorized entrants. We work with law enforcement agencies at the municipal and provincial level. We have close collaboration. Since 2016, when the number of claims have been on a rise, we already set up a good liaison with them. And according to the mainland authorities, in the mainland's territory, they have been able to intercept prospective illegal immigrants to a tune of 150,000. And they also managed to crack down on syndicates and made arrests. So we're grateful to the law enforcement agencies in the mainland. Next, in terms of emergency response, there are 14,000 plus claimants stranded in Hong Kong, and we do conduct regular reviews. They are allowed to be released on reconnaissance on the condition that they report to the Immigration Department regularly. So we keep the situation in view. If they are considered posing a risk to the overall safety in Hong Kong, they will be detained in the CIC. In fact, we have increased capacity. As for judicial reviews, the success rate is so low, it is below 1%, indicating that there is abuse. At the same time, the judiciary has implemented measures to tackle the issue. Perhaps I'll stop here, Chairman. Next, Deputy Chair. The last to speak. Thank you, Chairman. First of all, I support this proposal. Bogus refugee has always been a thorny issue. The bottleneck has now moved on from the screening stage to court proceedings. At the moment, the High Court processes leave for application to apply for judicial review, and the backlog is so serious that they are still processing cases in 2019 while we're in 2022 already. As for illegal immigrants, some of them arrived in Hong Kong 10 years ago. In other words, a lot of these claimants have stayed in Hong Kong for over 10 years. The reason is that they do make full use of every avenue in our legal system, such as judicial review, judicial review out of time, and once they don't stand a chance, they start with a subsequent claim request followed by another judicial review application. So like the administration explained, there is a restricted procedure order, but I don't think it is effective because the order provides that if you want to file a judicial review, you need to apply for leave with a judge. So that's the way they will go. As for the RPO, it entails a right of appeal. So it's just a repeat of the whole process. They can start again anytime. My thinking is that you need to have a government policy. At the moment, the court procedures will need to be completed before the claimants can be deported. And as long as you have initiated the court proceeding, you can't be deported. That accounts for the abuse. That is why I think the administration should consider fully with the relevant stakeholders how to prevent such an abuse. Any response from the Undersecretary? Chairman. I think we are familiar with the judicial review situation, and the judiciary has done a lot to improve the situation. For example, they have increased the number of judges at the Court of Appeal, and instead of a 3-judge bench, the appellant court now comprises the 2-judge bench. And there are also measures to prevent abuse of procedures, including Section 27 of the High Court Ordinance, which provides that unless with the leave of the court, a litigant cannot file another judicial review application. And as far as our part is concerned, once an order of this sort is handed down, we will proceed to removing the claimant as quickly as possible. I mentioned just now of the 222 orders issued. We already removed 57 of the subject of the order. And because of the epidemic situation and the situation in different countries and the available flights, we haven't been able to remove all of them. However, we do take note of Deputy Chair's view and keep in view the progress of deportation. If need be, we will approach the Legislative Council with another proposal. 12 members have spoken. I haven't heard any objection from members, so I suggest that this paper be submitted to the Establishment Subcommittee for further scrutiny. Any objection? No? Then that's the end of this item. All right, item 5, proposed amendments to the Births and Deaths Registration Ordinance. With us for this item, we have Undersecretary Mr. Sunny Au, as well as Mr. Hilson Fan, Assistant Director of Immigration. I will invite Undersecretary to walk us through the paper, and then the floor will be open. If you want to speak, please press the button, members. Undersecretary. Chairman. Last year, the Audit Commission conducted a review on Immigration Department's work on the management of births, deaths, and marriage registration, and the auditor, the director audit noted that a certain number of deaths from natural causes was not registered within the statutory time limit, and recommended the Immigration Department to explore measures to address the issue. Now, after the audit report has been released, the Security Bureau and Immigration Department conducted the relevant review, and we have found that deaths from natural causes had not been registered within the statutory time limit prescribed because the nearest relatives or other relevant persons had not been able to secure the supporting documents in time, and they also needed time to engage undertakers to make funeral arrangements. The second reason is that the ordinance was enacted back in 1934, and the prescribed statutory time limit have always been the same, and a timely amendment is necessary. According to the Immigration Department, around 99% of the deaths from natural causes were registered within 14 days. On this basis, we propose to extend the statutory time limit for registering death from natural causes to 14 days after the time of death. And we'd also like to take this occasion to make amendments to certain provisions to the of the births and deaths registration ordinance so that we will be ready for the introduction of electronic services. According to the ordinance, parents must register at the birth registries in person, and we propose for deaths and births, registration can be done by electronic means. Once the registration has been completed by the Immigration Department, the applicants can choose to collect a certified copy of a death entry or birth entry by post or in person at the registries. This will help avoid crowd gatherings and make it more convenient for applicants. Members are welcome to comment on the proposed amendments, and subject to the progress of drafting and members' views, we target to submit the amendment bill to LegCo in the first half of this legislative year. 5 members have indicated to speak: Mr. Tang CHIU, Ms. Elizabeth Kwok, Mr. Ronald Chan, and Deputy Chair, as well as Mr. Ma Fung Kwok. I'll give each member 3 minutes, questions and answers included. We start with Mr. Tang CHIU and Ms. Elizabeth Kwok. Please get ready. Under Secretary, about proposed amendments to the births and deaths registration ordinance. Of course, I'm in support. We need to streamline the procedures to extend the statutory time limits, as well as introducing electronic services, because in these dire times of the epidemic, we are seeing 7,000, 8,000 deaths. In the 5th wave, may I know, among the 7,000 or 8,000 cases, how many of them are deaths from natural causes? The point is, I've received complaints. There are cases involving the deceased being sent directly from hospital or not from hospital, because some patients passed away right outside the hospitals before they could be admitted. And the legal procedures, therefore, became much more complicated. So how many deaths among the 7,000 cases in the 5th wave were deaths from natural causes? So that's the first question. Second question, many relatives spend a lot of time trying to get a death certificate for death from non-natural causes. I'd like you to relay this view to the judiciary, that you should make it more convenient for members of the public to get a death certificate more easily. Under Secretary. Thank you, Mr. Tang, for supporting the proposed amendments. Mr. Tang asked about deaths of confirmed COVID confirmed patients, whether they died of natural causes or otherwise. As I understand, the majority of them died from natural causes. So at one point, there was a bottleneck at public mortuaries and the temporary mortuary at hospitals. I understand the Food and Environmental Health Department has made a lot of effort in ensuring the smooth operation of transportation of bodies of the deceased and cremation services. We do have a handful of patients who waited a long time before they were admitted, and a doctor's signature is required to prove or to confirm that the patient has died of natural causes. We have yet to collect the relevant figures, but I think the majority of them do not fall under the category of deaths from natural causes. So that is not under the point made in the paper. But I relay your view to the department. Ms. Elizabeth Quad, I support the proposed amendments. At the moment, for deaths from natural causes, relatives are required to register the deaths within 24 hours. It's really inconvenient. With extension of the statutory time limit, of course, it will be convenient for the relatives of the deceased. The other point is, of course, I strongly support the introduction of information technology. You can now electronically register or apply for registration of births and deaths. Again, I support it. I understand that the Immigration Department recently has made a lot of effort in clearing a backlog of death cases because of the COVID-19 pandemic. I understand you have a dedicated team for issuing death certificates, and we have 7,000 patients who passed away because of the COVID epidemic, and they died from non-natural causes, and it's very cumbersome to get a death certificate. I likewise have received a lot of complaints or inquiries or assistance because they're unable to get a certificate and they've waited for a long time. For ethnic minorities, they're required to because of their required to complete the burial rites within the short period of time. So I'd like to have an explanation on what assistance can be provided to the public in getting a death certificate. I think the bottleneck lies with the forensic pathology division. And meanwhile, I do understand you've done a lot.
Thank you, Chair. Thank you, Ms. Kwok, for the support for the proposed amendments and to support our IT progress. Concerning Ms. Kwok's questions and the incidents that she's mentioned, I believe most of them pertain to non-natural deaths. For natural deaths, the procedure now is quite smooth. And even during COVID time, now, some 98% of the natural cases even during COVID time, we are able to process the cases within 14 days and register them. So for non-natural deaths, they will have to go through the coroner, and where there is to be a coroner's court held, it will take even longer. Now, even without coroner's court, the coroner will have to look into and determine the cause of death. And where the case is straightforward, then the coroner would sign an order beforehand or early so that there can be a funeral or cremation held. And these orders will be sent to the Immigration Department, and within 1 to 2 working days, the Immigration Department will be able to issue the certificate of death. And of course, they will also contact the family members where there is no contact telephone number. They will post by registered post to the families to further process the funeral. So for non-natural deaths, where the coroner had already contacted us that there can be a registration of death, this is a procedure that we provide. Yes, Chen Chen-ying, Ronick. Thank you, Chair. I noticed that the 14 days, well, around 99% of deaths from natural causes are registered within 14 days. And what about the 1%? Why do they fall outside of the 14 days? Do we have any solutions for those? Because still there would be a group of Hong Kong residents who do not enjoy this registration system. And also the Immigration Department had already put into place where if the registration is done within 24 days, that's fine. For anything over 7 days, there will be, the informant would be inquired and asked to explain why. And if it is beyond that, then or 17 days to 14 days, then there can be certain actions taken. Now, given the COVID situation, will there be any leeway so that we do not have to be restricted by these 14 days, by this 14 days requirement for registration of deaths? Now, Mr. Chan had asked a few questions, Chair. 99% I mentioned. The 99% of cases follow that time frame, except for some special cases. Some of them have reasons that are excusable. For example, the registration documents are not there, or some overseas family members could not be reached, or the family members being numerous, they are not able to come to decision as to the mode of the funerals, let's say, under what religious rites that the funeral will be conducted, for instance. So we also understand that the family members will be aggrieved or will be grieving while arranging for funerals. So we understand that. And now with the change in the ordinance, we give more space in the sense that, as mentioned, if it is registered within 14 days, then there will not be any request for evidence or information as which is the practice now. So that is registration within 14 days. If it is done within that period, we will not be inquiring the informant or to ask him to provide explanation. All right, the vice chair of this panel, and then Mr. Ma, please. Thank you, Chair. I hope the bill can be forwarded to the electoral, introduced to the electoral as soon as possible, because the ordinance as it stands is grossly outdated. Yes, for family members, it is indeed a very, it's a grieving situation. Now, as for what is natural and what is not natural cause of death, it is difficult to tell for the family members. They will have to tell the two apart before they will know whether they fall within the 14 days or the 7 days requirement. And therefore, I hope that the Immigration Department, in your information pamphlets, also in your communication with the funeral services providers, hopefully through this and through simple wording, the relatives of the deceased will know what the legal requirements are so as to lower their anxiety and confusion. And secondly, concerning electronic application, I hope that for the applications on from electronic means, I hope that it will be very user-friendly. I'm sure people don't have to go through this process many times in their experience. So probably anybody going on to this electronic system will be using it for the first time. And the user, if they feel that this is not a convenience, but rather an extra burden, that would not be good. Let's say perhaps you can consider authorizing professionals such as funeral services providers to go online for them on their behalf. Perhaps this will help the family members of the deceased. Perhaps the department can consider these suggestions. Anything from the department? Yes, very good suggestions indeed. Thank you, Vice Chairman. Now, if the ordinance or the bill is passed, we will be communicating very closely with the funeral services industry so that they understand the new change. And also, according to the customs in Hong Kong, family of the deceased usually would go to a funeral service provider to carry out with the relevant procedures, funerals, etc. So therefore, the funeral services providers are definitely a stakeholder, and to allow them to help the family members to apply for the certificate so that they can provide one-stop shop service and to facilitate the family members, this is permissible. And in particular, in clause 14 of the ordinance, it says that the relevant persons of the deceased, so relevant persons of the should include funeral service providers. They can help with the registration process. And also electronically, we will be using the normal government e-platform. A lot more people are getting familiarized with the government comprehensive e-platform. And so we will be using this, the IM Smart platform. Yes, these are excellent suggestions. Chair, we will consider them. Yes, for the last member speaking this round is Mr. Ma Fung Kwok. Please unmute yourself, Mr. Ma. Thank you, Chair. I have a question. First of all, I'm in support of the proposed amendments, and definitely providing online application is good. So I'm in support of both. Well, I'm surprised, though, that this is an ordinance which was enacted in 1934, so that's over 80 years ago. I would like to know whether this ordinance had been enforced, especially in recent years. Had anyone been fined or penalized because of that? And secondly, definition. What are related parties or what are family members? Now, for related parties, just now, it's been described. What about family members? Say there is a person who had passed away, there may be a lot of relatives, and there may be a number of spouses as well, for instance. And what are the duties of these people? And under what circumstance will they be followed up by the authorities? You're not asking for the 80 years data, are you? No, data for the recent years. Well, certainly I can provide the past 5 years of data. For past 5 years, for the registration of births and deaths ordinance, two sides of that, births and deaths registration. For deaths registration in the past 5 years, we have had no prosecutions because, as members would know, the passing away of a family member is painful, and the relatives may be at a loss and confused, and they really would not know what to do. So we are very sympathetic to that. As for birth registrations, yes, there have been prosecutions in the past 5 years. So there had been about 30 cases of prosecutions in the past 5 years. And for birth registrations, it has to be done within 42 days. But some cases actually exceed a year, or one case exceeded 39 months before registration of the birth was done. And if there had been a serving of a notification letter or even calling on the person had come to not, because a lot of issues are relevant, welfare, etc., and for deaths, fighting for estate rights, etc., these may be happening, but the government would need an accurate registration or a register to accurately reflect the population situation. This is important to the department. The definition on relatives, please. That was my other question. Right. Actually, under section 14 of the registration of births and deaths, it says that it is deceased relatives or relevant persons. And under relevant persons, it further defines the person at the time of death, the deceased, the nearest relatives of the deceased present at the death or in attendance during the last illness, or any occupier or each inmate of the house in which the death took place. So anybody who knew the cause of death or had been present at the death would come under that definition. All right. Members have spoken.
So under Secretary, please note members' comments and consider members' suggestions in your upcoming legislative amendment proposal. Next item, proposed enhancements of information technology systems in the Immigration Department and the Correctional Services Department. We have Under Secretary again with us. We have Deputy Commissioner of Correctional Services, Mr. Hon CHIU, and also Assistant Director of Immigration, Mr. Chung, as well as Mr. Manon Tam from the Electrical and Mechanical Services Department. For other public officers, if need be, I will state their name. I will read out their names when they're called to answer questions. Members, if you want to speak, please press the button now. And the Secretary. Thank you, Chairman. This is an item on enhancements on information systems of the Immigration Department and the Correctional Services Department. There are 4 major proposals. The immigration's new headquarters in the Chang Kwan O will be commissioned next year. And along with this, we need to reprovision 18 existing IT systems and relevant facilities. They include 800 servers and 6,000 computer terminals. The Immigration Department is also required to update the outdated IT infrastructure and replace parts. And apart from information technology infrastructure, the Immigration Department would also like to take this opportunity to roll out 3 new systems, including the Next Generation Immigration Inquiry Service System, IESS2, so that we can introduce new features such as self-service inquiry kiosks and voice bots and voice navigation. Second, we'd like to have personal documentation submission and collection kiosks to facilitate the application and collection of passports and other documents in a self-service manner. The third system is the Central Services Queuing Management System, CSQMS, to facilitate the disbursement of tax for persons visiting our offices for inquiries. For the correctional services, the new CSD headquarters in Taiwan will be commissioned in 2024. There is a need to build new IT infrastructure and relocate the data centers, 3 information systems, and some 300 servers. There is also entailed in the proposal the development of a pharmacy inventory and warehouse management system. The second proposal is to set up a CSD Central Control Center or CSD CCC system and Geographic Information System GIS at the new headquarters of CSD in Taiwan. Under the new information technology strategy and to cope with emergencies. Lastly, in the 19 correctional institutions or facilities, would like to fully implement the persons in custody integrated intelligent communication system so that upon obtaining approval, a detainee can conveniently ring his relatives. We're happy to take members' questions and comments on the 4 proposals. Thank you. 4 members would like to speak. Each will be given 3 minutes. We start with Deputy Chair Mr. Lai Tong Kwok, Dr. Chow Man Kong, Dr. Johnny NG, and Ms. Elizabeth Kwok. So the floor is yours, Deputy Chair. Thank you, Chairman. I think the Immigration Department is a pioneer when it comes to using information technology. They use computers extensively and wins the acclaim of the public. So I further, of course, I support the Immigration Department's further introduction of information technology. As for the Correctional Services Department, I'm happy to see that they will continue to develop IT infrastructure to alleviate workload of their frontline officers, because the majority of their work entails manual operations. I hope they can make good use of the funding they applied for so as to enhance their capacity. I have a question about the CSD's computer system. I'm referring to Annex 2, Appendix 3, or Enclosure 3 to Annex 2. There is an implementation timetable for relocation of the IT systems. I don't quite understand it. I'd like the administration to explain to me. I see that some of the tasks take 5 steps, 6 steps, some takes 9 steps, and some of the steps entail security risk assessment and audit, but this item doesn't come under every task, just some of them. For some systems, there is no need to have a systems live run or user acceptance rather. Such as the first few items, I don't see user acceptance. Can you explain why there is this difference? Right, let me invite Mr. Ng, Deputy Director or Deputy Commissioner of Correctional Services to take your question. First of all, I thank the Deputy Chair for acknowledging our efforts in introducing more IT systems. Now for the enhancement proposal, you will see different, or the implementation timetable, you will see different completion dates for even procurement services. So let me invite Mr. Leung, Mr. Zhou Leung from CSD to explain the situation. Can you speak up, Mr. Leung? You may need to speak to the mic, please. Oh, you see a slight difference in the breakdown items of each activity. Basically, we conduct security risk assessment and audit for every activity. When it comes to, for example, establishment of data center, we don't have security risk assessment, because when it comes to data center, it's all about installing, say, fire services installations and server racks. So there is no security risk assessment and audit to speak of. Next, for user acceptance, this is a usual step in IT systems to be set up. But say when it comes to network infrastructure and data center, you see we don't have user acceptance because there is no such need. So basically that's a situation for these systems. Dr. Chow Man Kwong, followed by Dr. Johnny NG. Dr. Chow. Thank you, Chairman. to catch up with the digital gap with other neighboring cities in Asia in terms of the delivery of public services, I think I should support these proposals for the two departments. But I do have questions. Say for making applications online, I've heard complaints that users would be asked to upload documents onto the internet, but then at the backstage operation, the documents are still printed manually for processing. The problem is contact tracing is such a blunder that we see fatal cases. We should have a better understanding of how technology supports the delivery of public services, and that we need to digitize public services for greater efficiency. At the same time, we have a lot of resources spent on information technology, not only to enhance capability of the administration, but also to make our system safe and secure. Because of the global geopolitics, many countries have stepped up their efforts and resources in procuring cybersecurity related hardware and software. For example, you can have blacklists and whitelists of cybersecurity service providers to plug cybersecurity loopholes. May I know if similar measures will be adopted? Because after all, we're talking about a significant amount of funding. And these two departments are very much related to public interest. Under Secretary. Thank you, Chairman. Thank you, Member, for your support and your comments. And thank you for supporting digitization of our services. There are two comments. First, for online applications involving the general public as users, I think you're referring to the Immigration Department. So I'll defer to my colleague in the Immigration Department to supplement my answer. And I think basically for immigration services, you're referring to application for personal identity documents. And very soon, the next generation system will be put in place for online applications. We earlier received funding approval from LegCo. And if the next generation system has been implemented, visa applications can be made online. It's not just about uploading forms onto the internet. So be reassured, we are working on it. On security, you talk about a negative list. We haven't drawn up a negative list. Procurement and tendering comes under another bureau, in fact. But we have considered the concerns expressed by Dr. CHIU, especially when the Immigration Department and the Correctional Services Departments are law enforcement agencies holding sensitive data. So we'll make sure that we are prepared in terms of safeguarding data security. We also abide by principles of openness and fairness. Meanwhile, we conduct risk assessment, and in our tender brief, we also implement this. We also set out this requirement of upgraded cybersecurity arrangements. We also have a vetting process for contractors whom we find to be worrisome in terms of security. We're not going to allow these bids. As for possible embargoes and issues arising from trade wars, this will be fully reflected in our tender brief. And also the views will be relayed to the panel for selecting tenderers. Perhaps I'll just stop here. I am looking at the timer. Dr. Chow, please follow up on this question through other avenues. Next, Mr. Johnny Ng and Ms. Elizabeth Quat next. Thank you, Chairman. For the information systems of the Immigration Department and the Correctional Services Department, I speak in support of the proposals, and I'm all for enhancing your services to the public. And I understand that in terms of tendering, you make sure it's open and fair. And at the same time, I hope that more support will be given to local small-scale IT companies so that they can take part in the establishment of the major IT infrastructure. Next, I understand that the Immigration Department holds the most data of the general public in Hong Kong among all government departments. And yet I understand there have been gaps. It may have to do with data management. So after implementing the new system, another epidemic may come along. So I want to know whether you have any identity verification functions or tracing functions in your system in order to cope with possible major epidemic happening in the future. And in this scenario, you will be able to help the government.
As for correctional services, over the past few years, the Commissioner for Correctional Services had been putting in a lot of efforts into developing intelligent services or prisons. But I see a difficulty, and that is the buildings are really too outdated and obsolete. Now, if the prisons are to use IT well, it will take a lot of alterations, and that takes time and a lot of money. It will be very costly. And Chairman, we have been to visit a lot of correctional services facilities. Really, they are very obsolete, you would agree with me. So there is a need for the government to really provide for new prisons. The location of many of the prisons were in remote places before, but they are no longer so, those locations. So I think we should identify new locations for bigger, more comprehensive and IT-equipped prisons. So this would help with the correctional services work, and also it will be beneficial for Hong Kong community at large. So my question is, in using IT well, will you be considering the construction of a super prison, if you will, so that we consolidate some of our facilities and also update our prisons and facilities, and also to really be able to institute the smart prison? Thank you, Chair. Thank you, Ms. Kwok, for supporting the proposals from the for the Immigration Department and Correctional Services Department in enhancement on information system. In replying to Ms. Kwok, I would want to point out that for information systems for the Immigration Department and the CSD, there will be a lot of requirements in the third runway and the new Long Kong port, etc. There will be a lot of new workload and requirements for service. And for smart prison, there will be of course, it will need to be equipped with a very comprehensive system but for super prison, there is no plan as yet to build such a facility. It is going to be a very big project. We will need to identify the location, the land plot, and also it will need public consultation. And for this round, we have got the LegCo's approval for the relocation of the correctional services headquarters, so that in management and in resources and in providing quick response, and also in the management of the facilities under CSD, there will be a significant enhancement. And I think after the completion of that project, the Commissioner and also Mr. Ng here will be looking into the department's further needs, Correctional Services Department's further needs. Then they will be coming to us. Well, I hope that the government would seriously start the study of the super prison, because if you do not do so, it will never happen. So if you can start the study early, I think it will be beneficial to the entire community. Now, all members who have indicated they want to speak have spoken. So any declaration of pecuniary or direct or indirect pecuniary interests, are you in support of taking this to the Finance Committee? Any objections? None. So, okay, we forward this paper and proposal to the Finance Committee for further processing. AOB next. There are no AOBs. I declare this meeting closed. Thank you for the government departments and the Secretariat and staff for help. Thank you.